In the brief, Barnes respectfully submits this court should quash the final order of the Florida Elections Commission and dismiss the fee petition against him. Barnes requests to reserve 6 minutes for rebuttal. The 2012 High Springs election was hotly debated on local issues. A citizens group calling itself Concerned Citizens for a Better High Springs appeared and widely promoted reform principles, including a plea that the voters go all the way to the end of the ballot. Vocal members of the group opposed issues that Barnes supported. Barnes believed the organization was a political action committee and should comply with Chapter 106 Florida statutes, which it had not done. After the election was over, not before, Barnes determined to file a complaint with the Florida Elections Commission to ascertain whether the organization should comply with 106 to assure a, quote, fair playing field, unquote, in future elections. He did some research, including calling FEC about how to file a complaint against an organization. And from that, from what he was told, Barnes concluded that he must name 2 persons in the complaint. Yago identified herself to him as the spokesperson for the organization and the person to contact about its mission. After Linda Jones later identified herself as the vice president, Barnes filed his complaint naming Yago as respondent. This was well after the election was over. Barnes asked FEC to investigate and to determine whether the organization should comply with Chapter 106. He made absolutely no personally defamatory statements about Yago or anybody else, none. The FEC executive director denied Barnes' complaint on the grounds that Barnes had not shown that the organization was sufficiently engaged in express political advocacy. Yago filed a petition for fees and costs, and after a sequence of highly irregular proceedings, much of which Mr. Barnes was unaware of, an administrative law judge recommended fees and costs be awarded against him in the amount of $42,360. The FEC final order on appeal here adopted that recommendation. Barnes appeals from the final order on 5 independent grounds in the briefs, all of which he adheres to, including particularly the First Amendment argument. In the argument here today, however, he focuses on a glaring legal defect in the final order that requires reversal and dismissal as a matter of law. To obtain a Section 106.265 fee award, Yago was required to prove inter alia by clear and convincing evidence that Barnes filed his FEC complaint, quote, with a malicious intent to injure her reputation, unquote. And in addition to that, there was a pre-trial stipulation that required Yago to prove the same thing to the standard of clear and convincing evidence.
Well, counsel, let's address that point precisely. One of the findings by the ALJ was that Ms. Yago was compelled to hire counsel and vigorously defend against the complainant's allegations in order to protect her professional reputation as an ethical person. These were not statements made in the media or at a public forum. These were complaints filed with a judicial, quasi-judicial body that would potentially implicate Ms. Yago in criminal conduct, expose her to fines. So why wasn't that finding sufficient to meet that first standard?
The question is, what was Mr. Barnes' intent, not what she decided that she was going to do to defend herself. She didn't have to do anything. The executive director defended dismissed the complaint on its face as facially insufficient. So what she decided she must do does not have to do with his intent. That has to do with what was in his mind. And there's absolutely no evidence whatsoever that he ever had any intent to injure her reputation.
Doesn't the Brown case, our decision in Brown, stand for the proposition that malicious intent can be inferred from reckless disregard of the facts? And isn't there sufficient evidence in this particular order that that was in fact the case?
I don't think Brown stands for there being malicious intent to be inferred from anything in this case. Every case that has awarded fees has been one in which there was some actual animus of some kind between the person who made the complaint and the person against whom the complaint.
In Brown, where the property appraiser in Santa Rosa County was awarded fees by this court on appeal, after an appeal, Judge Padovano wrote the opinion, as you know, and Judge Wolf wrote a concurring opinion. As I recall the facts in that case, Robert Burgess suggested that there had been some improper adjustments on a church property.
Correct.
And there was also, I think Ivy Kelly or Ivan Kelly suggested that there were some improper adjustments on another piece of property. That second piece of property had actually burned to the ground. And the first piece of property, the church, had not received proper notice.
Correct.
And so those were the adjustments. Now, in both of those situations, Robert Burgess was not intentionally maligning Greg Brown. He just made a mistake. And the other person acknowledged that they didn't pursue the record very carefully, and they made a mistake. They didn't know the property burned to the ground. So you can't suggest that Brown stands for that proposition that you just argued.
I think you can, Your Honor, because the purpose in those cases was to defeat, I think it was Brown's reelection campaign.
Greg Brown, yeah.
That was the purpose. And there was no such purpose in this case. The only purpose here was to find out whether or not this organization,
which this lady was not part of the hierarchy of that organization.
well, she was the spokesperson for the organization and the person that developed this policy statements. This is in the record. It's undisputed.
Well, setting Brown aside for a minute, if we just looked at the plain language of the statute at issue, it seems to me that malicious intent, that requirement is defined and it's narrowed by the language by filing a complaint with the knowledge that the complaint contains one or more false allegations or with reckless disregard for the veracity of those allegations. And so to me, just reading this, it doesn't necessarily require an actual malice or an actual finding of malicious intent. So tell me how my plain reading is incorrect.
Well, I don't understand, Your Honor, how you can ignore the language in the statute that requires malicious intent. If you go to Tapper against Taunton, the case decided by this court involving a fee matter, there the statute required frivolousness and malicious intent.
Right. So that
and this court said those are two separate requirements. And in that case, the court says there's not enough evidence of frivolousness. We don't even have to worry about malicious intent to dismiss the matter. So there's nothing more settled than in order to get a remedy under a statute or under the common law, you must prove all of the elements of the cause of action. And this simply has not been done in this case. And the record does not permit such a finding. In this case, Mr. Barnes threw out the matter, including that stipulation, including in recommended orders to the ALJ.
Mr. Little, how does one prove malicious intent?
You prove malicious intent by showing that the person had some animus against the person
You can't prove malicious intent by actions?
You can prove intent by actions, Your Honor, but it has to be to hurt the person. To hurt the person, to damage her reputation.
Well, doesn't that go with go to the issue of reckless disregard? If you can prove by actions that something that by somebody's action and reckless disregard for the facts, that the reputation was damaged or the person was damaged, does that not create the necessary nexus under the elements of the offense or the elements of the?
I think it is not. No, it's not, Your Honor. There are two sets of requirements. Malicious intent
Right.
to injure the reputation.
Right.
That is a matter with malice
Right.
separate. And the Supreme Court of Florida said in State against Kettle and other cases, when you've got malice connected with an act like that, you've got to prove malice, you see.
And you prove that by acts.
And you prove that by acts or by evidence that a person had some ill will against a person, of which there is none in this case, or that the person did something that was inappropriate. And that's not the case here. Mr. Barnes wanted to find out whether or not this organization should comply with 106. There's nothing inappropriate about that, you see. You see, this is one of the problems here. When can a person file an action without having to worry about being mulched for attorney's fees if the test is as was applied in this case? Your Honors, I'd like to reserve the rest of my time for rebuttal. Thank you.
Thank you.
May it please the Court, Paul Regensdorf for the appellee, the original respondent, ultimately the petitioner on fees, Sharon Yago. I think this Court has the issue precisely. I've been here a few times before and done a few appeals. I don't think I've ever seen a case where there is a reported decision from the court before whom I'm appearing that answers every single question better than this case. And that case is Brown versus Commission on Ethics. If you go through and read this case closely from start to finish, it specifically addresses in advance every single one of Mr. Barnes's points. Essentially what he is claiming is that there are three standards of proof of malice. He is seeking the absolute highest standard that, as far as I know, other than perhaps in a criminal case, has never been applied in any situation like this. That is the ill will, the hatred, the personal animus standard that I discuss in my brief as unfortunately being brought in by some people by use of the word malice. That's the malice in fact, mens rea, specific intent. I want to hurt you standard of malice. That was specifically rejected by this court in Brown and said, that's not what we're talking about. Brown very carefully discusses then, after it rejects that, the next two levels of malice. The middle one, which is still very high, was, again, it's called actual malice, but it's the New York Times v. Sullivan type of malice. It's not proved by animus or hatred or spite or ill will. Quite the contrary. It's caused by a relatively high certainty that the person who said what he said, or she, knew or should have known that it was false. Relatively high, a high degree of awareness. Not anything to do with inside the head, because that's almost impossible to prove, other than, as Judge Swanson says, by acts. And the court, for about 6 different reasons that I'll spell out if I have some time, went through and said, that standard, that high standard, that constitutional standard for personal figures and defamation actions, New York Times v. Sullivan, distinctly inappropriate in this case. So then it said, what is the next standard? The next standard, never really defined. It's essentially legal malice or inferred malice. And that is precisely what the statute in question calls for. Now, on page 556 of that opinion, the Brown opinion, the court described very generally what it is. It says, the statute provided that a person who files an ethics complaint, here an elections complaint, against a public official, here Ms. Yago, although she was not a public official, is liable for costs and fees if the complaint was made with a malicious intent to injure the reputation of the public official, comma, in that the facts alleged in the complaint were known to be false or made with reckless disregard for the truth. The malice, as Judge Race accurately described, is inferred in this case. The legal malice, this lower level of malice, is inferred from the fact that Mr. Barnes filed things that were just blatantly untrue, and actually he knew it because he attached to his very complaint the documents that described the untruth, and yet he continued and proceeded and continued to tell that story through his sworn testimony in court. So that's where it started. The court, in the very opening paragraph, rejects that actual malice standard, and here are some of the reasons why even that middle level of standard, I think Mr. Barnes' conduct in this case is reprehensible and would fully meet that standard because he did know that, but I don't have to prove that. All I have to show is reckless indifference to the facts, and the ALJ in this case made repeated findings of that, after laying out exactly what the statutory requirements were, saying they're met here, and here's why: conscious indifference, paragraphs 49, 51, and all through the facts. Here are some of the reasons why this court made a decision that is absolutely binding and wisely binding on this panel today. First of all, it said, well, let's look at the statute. It doesn't use the word actual malice. Why should we infer this higher standard when they haven't used the word actual malice?
If I just interrupt just real quickly right there, I think one of appellant's main contentions is that there was never even a finding of malicious intent in the order. And of course, your position is that it can be inferred, but is that problematic because the magic language was not used?
Not in the slightest, because they said what they had to find, and he did. I will concede that there was no specific finding of personal animus, hatred, spite, ill will, to the extent that that means malice. But malice is defined in the statute, and it's described very simply as reckless disregard. As this court said on page 555, it's malice in that they were filed with reckless disregard. This court said in Brown that a statute 104.271, I think, is a completely different statute. That was argued by Mr. Barnes as well, and they argued that somehow gives a different argument. And Brown, in advance of that argument, said, well, no, that's not true, because the statute there very specifically used the actual malice test. It referred to the words actual malice. The Sharkey case later on, 5 years after Brown, applied that using the actual malice standard. Then this court went further and gave another reason, a common sense type reason, and that is, why should we apply the higher constitutional standard in this type of a case? In the Section 104 case, it was a case where two candidates were making charges against each other during a campaign. It's the ultimate in political debate. The courts and the legislature, more importantly, want to be very careful not to infringe upon that high level of public debate. And that's why the legislature said in that type of a case, if you file a false complaint, you better have actual malice. Not malice, ill will, spite. No. Just the higher degree of awareness that the New York Times statute applies. But in this case, and the Brown court again went on at great length to draw the distinction. In this case, we've got a situation where this wasn't some sort of a public comment. It certainly wasn't a comment like on a stump speech or something. This wasn't a campaign debate. This was a complaint where Ms. Yeagle was hailed into court and charged with very serious violations of the law that led to criminal or other penalties. Now, in a typical public speech situation, the person can ignore it or reply. She had no choice. She had to respond. And that's exactly what Brown said. When you hail someone into court with one of these, we're not going to hold the wrongdoer to this higher level of standard, because Ms. Yeagle is not making a claim in this case for her personal suffering, for her mental pain and suffering, for her consequential damages, other than having to defend herself, getting hailed into court. And the Brown case says, in no uncertain terms, that sets this case completely apart from the higher level of malice, let alone the factual level of malice of ill will, spite, anger, whatever, that Mr. Little apparently now seeks for the first time anywhere that I can find in any kind of a public speech case has ever been applied. It simply has never been applied. And then finally, although I've got a lot of time if there's not more questions, then he finally makes a constitutional argument. And I ended up trying to write one, and I ended up just quoting about a page and a half of this court's opinion at the end of my brief, because they again explained the difference between the constitutional protections of important public speech. In the New York Times, it was against a public figure. In the Section 104 case, it's two public candidates going at each other, making charges, at a public debate, one against the other. They really want to make those sorts of things protected to the extent they can. And so the legislature, in its wisdom, ratcheted the level up to actual malice. Judge Wolf, in his concurrence and even the dissent, even the majority opinion in Brown, said, if the legislature wants to, for some reason that the Brown court could not understand, if they wanted to ratchet the level up for false, malicious, reckless charges against Ms. Yago, in this case, if that's what they wanted to do, they could very easily do it. Now, this occurred in 2012. It still hasn't been done. Certainly it wasn't done since 2007, when this court wrote the definitive, precise opinion that just laid out point after point after point after point after point.
Let me take you back to that opinion,
Yes, ma'am.
the Brown case, of course. The appellant cites a portion of our opinion on page 560 of the opinion that seems to indicate that there's three separate and distinct requirements that must be found. One, that the complaint was made with malicious intent to injure.
Sure.
Two, that the statements were false or made with reckless disregard, and three, that it was material. And that portion, taken in isolation, does seem to suggest that a malicious intent requirement is a separate inquiry from the other two and essential. So can you respond to that particular
Absolutely.
argument in the brief?
And I think you actually answered your question, and thank you. Taken in isolation, does that seem to suggest that there must be something else there that you have to prove to accomplish that? It could, but the point is you cannot take that in isolation. Why in the world would you have to prove actual malicious intent and reckless indifference of falsehood? If it's reckless indifference intent, that's all that matters. So when you read the entire opinion, what they have done is defined malicious intent, in that it was filed with reckless indifference or knowledge of the falsity. It could not be clear. I'll be perfectly candid. When I first read that opinion, I got to those three parts, I went to Judge Padovano, this wonderful judge. I went, huh? But I think you cannot take those portions and write out the preceding 10 pages or whatever it is of the opinion, because it could not be clearer as to the malicious intent that is being talked about in that. And that is that which is proven by, to the extent that the fact finder so finds, that there was reckless indifference or actual knowledge of the falsity. And in this case, of course, the ALJ, despite this high burden that Ms. Yago was put to, found over and over and over that precise degree of conduct that is malicious intent, as the judge recognized, the ALJ recognized in her order, and as Brown recognized by the clear meaning of the statute. So, again, I always hate to hitch my star to a single wagon or my wagon to a single star, but it's awful hard to go beyond the Brown case. I have gone beyond it in my brief, but you can look at this thing and read it from start to finish, and it is a textbook answer to every single point in this case. And if the court has no further questions, this is a really rare occasion. I may stop and honor the Marshal's request to do something else, but I'm not going to. I'm simply going to say, therefore, I would ask that this case be affirmed. There is a motion for attorney's fees, which has been filed. I don't believe it was opposed, but if you look at the statute, and if you look at the rules under which the statute, the rules that were followed, that flowed from the statute, it's an unusual fees statute. Normally, it's not a prevailing party fee statute. Once the entitlement is over, you're done with fees. Quite the contrary. It says that you can get your reasonable attorney's fees incurred in the defense of the person complained against, including the costs and reasonable attorney's fees incurred in providing entitlement to and including in proving the entitlement to and the amount of costs and fees. Obviously, we're still fighting entitlement because they have not exactly acknowledged their obligation to pay fees. So I'm fighting entitlement. Ms. Yago is entitled to fees throughout this proceeding, and candidly, since the ALJ's opinion only covered through the final hearing in front of the ALJ, which was now that was back in, I don't know when it was, a long time ago, 2014, I believe. April of 2014 was the last hearing in front of the ALJ. There has been substantial time spent since that time in defending just this activity, and when this matter is affirmed, as I hope it will be, and when the motion for attorney's fees is granted, as I believe it has to be if this case is affirmed, on remand, we will be asking not only for the fees for this appeal,
But you're relying on section 106.2656?
I am, and it's about two-thirds of the way down.
And your position is that the appellate fees and costs are awardable under that section?
Absolutely, because we're still fighting. I'm sorry?
Mr. Regensdorf, just say that, your point again, that it was real brief, that because
Sure.
you continue.
We are entitled to our fees so long as we are seeking to establish the defense, including the cost of fees incurred in proving entitlement to and the amount. And since Mr. Barnes, in his wisdom, has chosen to fight this every single step of the way today, denying Ms. Yago's entitlement to, I am here fighting and will continue to fight for the entitlement to. And when I go back, we'll proceed further on other fees that occurred since April of 2014 when the ALJ last heard evidence in this case. So for those reasons, I have 4 seconds. You see, I did make it, and I would ask that this case be affirmed. Thank you.
Thank you, counsel.
Your Honors, Mr. Regensdorf has got a very peculiar and extended notion of what Brown holds. The primary purpose of Brown, of course, was to decide that the statutory requirement of malice was not constitutional malice. I personally think that was a mistake, but that doesn't resolve this problem. This problem is that there must be, the statute is clear. It has got separate points of view, and this court cannot read the statute away, and certainly Mr. Regensdorf can't.
Well, would you concede that in Brown, Mr. Burgess and Mr. Kelly, Hilton Kelly, did not intentionally misstate the facts? There was arguably a reckless disregard for the information because they failed to inquire and validate the allegations that they made. So that was not intentional. It was a reckless disregard. That's in essence what the facts of Brown are.
Well, Your Honor, the question of intent to damage the reputation is the primary appeal here. And Brown did not really address that greatly, but it assumed to accept that that finding had been made. I don't know.
But in that, that's a fee case. And in that case, the two principals, Robert Burgess and Hilton Kelly, made assertions about Greg Brown, the property appraiser for Santa Rosa County, concerning a piece of a church property and a piece of residential property.
That's correct, Your Honor.
Residential property burned down, and
Correct.
the person didn't know that. The church property was improperly assessed on the basis of a failure to provide proper notice. Robert Burgess didn't know that. So it wasn't intentional. It was
Well, I
a
don't know
reckless
that, Your
disregard.
Honor. I'm not sure that's spelled out in Brown.
Oh, it is spelled out. Those are the facts of
Well,
Brown.
Your Honor, I don't think that controls this matter.
Why doesn't it? It's the same statute.
And read the complaint in this case.
Mr. Little, it's the same statutory scheme.
Yes, Your Honor, but we've got different facts. Read the complaint.
I know, you have different facts.
Mr. Barnes did not make any allegation against Ms. Yago. Nothing. In that case, there were allegations that the property appraiser was not doing his job, that he, in fact, was cheating on his public responsibilities.
Which proved to be false.
And there is no such allegation here. Mr. Regensdorf talks about the awful things that Mr. Barnes did. At worst, he said that, that a 4x4 poster, which did exist.
Mr. Little, Mr. Regensdorf isn't talking about. That's the order that this court was provided by a lower tribunal. So it doesn't matter what Mr. Regensdorf says or doesn't say.
And Your
We're
Honor,
dealing with a lower tribunal that made certain findings of fact.
and we have in our appeal, we have said that those findings are not supported by competent substantial evidence in the record, and they are not. If you take a look at the findings in this case, this court must decide that all of the elements of the cause of action have been proved, and they have not. And for that reason, Your Honors, we respectfully request that you reverse this, quash this order, and dismiss this appeal, dismiss the petition. Thank you very much.
Thank you.
Thank you, counsel. Thank you both. This court will stand in recess.
Thank you.
All rise.